Hello everyone, this is Pammy Jaiswal. Today, we are going to discuss about the recently introduced Industry Standards Note on Regulation 30. This circular has been brought by the Industry Standards Forum in consultation with SEBI. So let's begin with the presentation. If we have to look at the applicability date of this particular circular, we do not find any specific date being given there. Therefore, it becomes clear that this particular circular is applicable on the listed entities with immediate effect. That is, on the date of the circular, which is 25th of February 2025. Now, why this circular was introduced? To facilitate uniform approach while filing intimations under Regulation 30. Talking about some of the major highlights under this circular. The first is, let's say, under Part A, Para B, they have linked the measurement of determining the value or the expected impact of the value with the use of the PPR test, which is the probable, possible, and remote test aligned with Ind AS 37. Next, they have also introduced or given the clarification of assigning the expected impact in terms of value with a timeline of 4 quarters. Another very significant clarification, which we already had this view before, was an event when measured against the thresholds of materiality under Regulation 30/4, the same needs to be compared with the relevant financial parameter. Because there are 3 parameters: net worth, turnover, net profits. So it might happen that a particular event might not have any impact on net worth, or it might not have any impact on the net profits. But because the requirement is to consider the lowest of the 3 thresholds, many companies were still required to make intimation under the said regulation. The next highlight of the circular is that they have clarified when it comes to understanding the significant market reaction for the material price movement. They have simply referred to the MPM criteria brought by SEBI. Next, talking about the disclosures of actions and orders, which is specifically coming from Part A, Para A, Clause 19 and Clause 20. Therein, they have specifically brought the list of sectoral regulators and enforcement agencies, which was not there before. Similarly, they have clarified that the actions or orders against the directors, KMPs, SMPs, promoters, or subsidiaries are going to be disclosed only if they have impact on the operations, finances, or reputation of the listed entity. Coming to the next highlight, which talks about cumulation for litigation. That means similar legal or factual matters are to be aggregated if they are likely to have a similar outcome for the purposes of deciding whether the same crosses the thresholds for making it a material event. Next is redaction of certain information which are confidential, and in fact guidance has been provided on the content disclosure, including the handling of confidential communications. The next highlight is about the thresholds for acquisition, which has now only been linked to the net worth when it comes to certain types of entities like insurance companies, NBFCs, and registered CICs. Not only this, but there are several other clarifications and guidance brought under this ISN. So let's move ahead. First, let's talk about guidance on Para A items. So as I mentioned, for acquisition by NBFCs, registered CICs, and insurance companies, only the threshold of net worth, which is that if the acquisition by an listed NBFC, insurance company, or registered CIC crosses the 2% net worth as per the last CFS, that will require disclosure under this particular thresholds. For any other type of acquisition, that means in case of an unlisted entity being acquired, the lowest of the three thresholds, that is 225, given under 30/4, has to be seen. Now here it is important to note that there has been few provisions under this particular circular which looks like going beyond the need or beyond the ambit of the regulation. Like this particular clause for acquisition covers only the voting rights, shares or voting rights. But here, if you look at the guidance given by in the ISL, it talks about debt security as well. Now, also this particular clarity or this clarification has not been extended to banks or stockbroking entities. Coming to the next guidance which has been given under this ISIN is that when it comes to actions taken by any sectoral regulator, enforcement agency, etc., on the KMPs, SMPs, promoters, subsidiary, then that will require disclosure only if it is in relation to the listed entity and it has an impact on the operations, financial position, or reputation of the listed entity. Now, this is unlike the earlier situation where an entity was required to disclose the impact when giving the intimation. Also, since the list of sectoral regulators and enforcement agency has been defined for several industries, it becomes more clear for the listed entities to know which will be falling under a sectoral regulator fine or a penalty. Next, we talk about clarification regarding timelines for disclosure of fraud. Now, for frauds related to the listed entity, needs to be disclosed within 24 hours from the earlier of completion of the prima facie assessment or within 4 weeks of the listed entity becoming aware of the fraud. So, whichever is earlier, if the assessment, prima facie assessment is completed or the listed entity has been made aware, it has come to know about the fraud and a timeline of 4 weeks has passed, earlier of the two, it will be required to make the disclosure. Now, the final disclosure, of course, as an update will have to be made once the investigation is concluded. Next, talking about frauds pertaining to the promoter or director or KMP, SMP subsidiary of the listed entity, the same needs to be disclosed within 24 hours from the officer of the listed entity becoming aware through credible and verifiable channels of communication. And fraud that does not involve the listed entity or not in relation to the listed entity's activities will not require a disclosure. Here, what we need to understand that a prima facie assessment is required to establish the occurrence of fraud. So just allegation of a fraud will not tantamount to the event taking place. That means there has to be some prima facie assessment, and only if, as per the prima facie assessment, the fraud has been done, has occurred, then only the intimation will be made. Next, talking about disclosure of winding up petition filed by any party or creditor. Here we're talking about the trigger point being upon admission of such matter by NCLT. Now, listed entity shall disclose only such petitions which are validly filed by eligible parties like the financial creditor, operational creditor, or the company itself under section 271, 272 of the Companies Act. Next, talking about clarifications regarding disclosure of resignation of KMPs and premature announcements made by KMPs. Now, this particular clarity was much needed because always there is a gap between, an officer resigning and the actual date of the resignation, because there's always a notice period coming into the picture. So here, if I have to talk about the clarity that has come in, it's very simple that whatever is the actual date, the effective date of resignation, the disclosure has to be made before that. So for example, if X is resigning on 1st of January and the resignation is accepted on 31st of January, However, the last day is only on the 28th of February. The listed entity is required to disclose the resignation latest by 29th of February 2024. And of course, the reason, the resignation letter with reasons has to go within 7 days thereafter. Also, there has been a clarity given that certain specific portions of the resignation letter can now be redacted while making the disclosure. Coming to the next clarity, disclosure of announcement or communication through social media intermediaries or mainstream media. Here, if directors or promoters, KMP, SMP, or of the listed entity make a premature announcement or a communication, the listed entity will have to issue a clarification that this is still premature and updates will be intimated appropriately. Coming next on analyst meet. So for analyst meet, 2 working days intimation has to be given in advance. However, this is not applicable for the analyst meet done on shorter notice for urgent matters. Now, the schedule has to be simultaneously submitted to the stock exchanges along with the explanation of shorter notice. And very importantly, such meetings shall not be preceded or succeeded by any one-to-one meetings. Now, here, of course, we anyway say that one-to-one meetings are not desirable and therefore they should be avoided because they carry a very significant risk of, that there could be a leak of UPSI. And therefore, this particular principle is of course a welcome clarity that there cannot be an incident of a analyst meet being called on a shorter notice wherein the same is either preceded or succeeded by a one-to-one meeting. Some of miscellaneous changes under Part A, Para A is, of course, when it says last audited consolidated financial statements, it means the last consolidated financial statements. Also for disclosure of proceedings of AGMs and EGMs of the listed entity, while the voting results will go within 2 working days, however, certain specific details such as the date of meeting and brief details of items deliberated are to be disclosed within 12 hours. Coming next on guidance on Para B items. Now here, we talk about a very, very significant guidance which has been given, that is the interpretation of the value or the expected impact in terms of value under Regulation 34, Clause 1, Subclause C. Here they've clearly specified that when we are measuring or when we are actually assessing that whether this particular event has the value of, it's crossing the value of materiality or is expected to cross the materiality thresholds, we have to consider the 4 ensuing quarters from when the event has taken place. Now, one particular guidance here is that if the event has taken place within 60 days from the start of the quarter, then we need to include that quarter. Otherwise, we exclude that quarter. Next is the decision to disclose or not disclose has been linked with the reliance on the PPR test, which is given under India 37, so as to ensure consistency between the stock exchange disclosures and the disclosures made in the financial statements. It clearly specifies that if the outcome of this test is within probable or possible category, then disclosure will be needed. However, if it has a remote possibility, it is a remote category event, that means there is very, very less chance of the event happening, then there is no need for you to make any disclosures. Then we come to the next part, which is amount to be considered for ascertaining the impact for Para B items. Here they say that you have to consider the gross amount involved if it exceeds the thresholds. Now, details of indemnity and insurance claims which could mitigate the expected impact may be disclosed. And of course, to provide more context. Again, the principle of redendo singula singulis, which is the RSS, has been again explicitly introduced in this circular, which we have always been advocating. And that is like whenever a particular event is being measured, that whether it is material or not against the thresholds under Regulation 30/4, each event has to be seen against the most relevant threshold. So something which impacts my net worth, let's say there is a capital investment and it's going to impact my net worth, but because the net profit criteria is lower, Hence, the company is required to make the disclosure without even understanding whether it is at all relevant or not. So moving ahead, if you have to look into this particular RSS principle which they've got, it's very clear that they're talking about assigning or linking an event to the most relevant threshold rather than just simply, taking the lowest of the three and making the intimation. Now, cases where, let's say, impact is on the turnover or on the profit, it is negligible. However, the impact on the net worth is substantial. In such a case, disclosure should be made on the basis of the impact on the relevant threshold and not the lowest of the three. Another example is, let's say we are setting up a factory for capacity addition. It may not have any immediate impact, but may have impacts, in the ensuing 4 quarters. So therefore, however, it may result in capital outflow as well. So here we need to look at the expected impact in terms of value as well as linking it to the most relevant threshold as per the RSS principle. Now, lower of the below as indicated in the ISN it cannot be expected to be like 0. Therefore, one has to, if any of the 2 to 5 parameters get triggered by applying the RSS principle, then the appropriate value, the most relevant and the appropriate value needs to be considered as a base for making disclosure. Again, another clarification is on regarding the cumulative basis for disclosure of pending litigations. Here they're talking about accumulating those cases which are of similar nature, or the outcome is of similar nature. There's a likelihood of similar question being decided, similar principle being decided, and therefore the impact on the values, the thresholds when being assessed can be accumulated for making the intimation. For example, the tax matters, some facts and legal issues accumulate. If one proceeding is held against the entity on merit of law, then others will also be held against the listed entity. Let's say in another matter, there are several tax matters and they're all with different facts, right? So, and therefore there is no question of accumulating. So we are accumulating those events together which are likely to have similar outcome or are on the similar questions of law. They're on the similar facts. So they are required to be accumulated as against those which have different facts and therefore the outcome is not interrelated. Next, of course, guidance on significant market reaction. They have clearly stated that it has to be as per the parameters specified by the stock exchange, which is on the material price movement. We're talking about next on guarantees and indemnities, and of course, relaxation for WS, because Part A, Para B, Clause 11 talks about disclosure of guarantees, indemnities, surety for any third party. So it is not required for those provided to the WS that are consolidated in the listed entities financials. However, if the WS ceases, right, or is that there has been an invocation, that will require an intimation. Next, coming to contractual performance guarantee, here also, if it is in the normal course of business, it will not require a disclosure unless it is invoked. For listed banking insurance companies, following will not require disclosure until revoked, that is indemnities, guarantees or surety bonds issued by the listed banking companies or surety insurance provided by the insurance companies. Now here, of course, we need to understand that the guarantee is generally an offset, it's an off-balance sheet item, and this needs to be net off with any counter guarantee which is given. And ascertainment of the impact of invocation of guarantee cannot be bereft of netting off of the account on account of any guarantee or counter guarantee being given, which means that, of course, if I am considering the amount in terms of the guarantee given, and if I have in turn been given a guarantee, then I need to net off that guarantee or counter guarantee given to me in order to assess the value of the guarantee for the purposes of intimation. Next, coming on disclosure of frauds or defaults by employees of the listed entity, the definition of fraud has to be taken by from the party para A clause 6. And of course, the timelines are as per para 12. Delayed disclosures, there are certain defenses which are introduced. And I think this also, as we just discussed, these were already there in the SEBI Master Circular dated 11th November 2024. So here it specifically states that the timeline for disclosure will commence only once an officer has become aware about the information through credible, verifiable channels of communication. So that means there has to be an appropriate system in the listed entity for prompt internal reporting, and there has to be specific, frequent training sessions so that they know what are the changes and what is their role in escalating the matter for the purpose of prompt disclosure. Now, permissible defense for delayed disclosures are force majeure events or maybe time taken for prima facie assessment of materiality for certain relevant events such as orders, fraud, action initiated, claims made against listed entity, etc. Information or event related to subsidiary, director, KMP's promoter, where the listed entity is not directly involved. And of course, any delay has to be supported with an explanation of why the delay happened. Now, when I say that this was more or less some of these were all, like the one which is when the officer comes to know about the event is only when the timeline is going to start, was already there in the SEBI Master Circular. And the term officer was also defined to refer to the officer as per Companies Act. And there are certain miscellaneous items for which guidance has been given in this ISIN, which is when it comes to the disclosure of confidential litigation, dispute, order, or action initiated, then the confidentiality has to be ascertained under any applicable law or requirement direction of any regulatory statutory body or quasi-judicial body, and applicable for the following disclosures. That is, this particular defense or this particular relaxation is for like actions initiated order passed under Part A para 19, actions taken orders passed under Part A para 8 clause 20, litigation to dispute as per Part A para B clause 8. And what is to be done if an information is considered confidential? Then the requisition to disclose the communication received under Regulation 30/30, it will not apply. And one can put the key elements of the information as per the disclosure content given in this particular ISIN. Disclosure of events and information emanating from board meetings, disclosure in PDF format has to go within 30 minutes or 3 hours as per Regulation 36(1). However, XBRL format disclosure can go within 24 hours from the conclusion of the meeting. Next, talking about disclosure communications as per Regulation 30/13, as we said that, there is a particular annexure which gives you the format of how to disclose the confidential or what to disclose when it comes to intimation of any confidential information. And the format has been given by in the ISIN itself. Next, last we talk about actionables after this particular item has come in. So first is, of course, to make appropriate amendments in the materiality policy to maybe give reference to the name of the sector regulators or enforcement authorities, depending on the business of the listed entity. Amendments in the Fair Disclosure Code to the extent of including the timelines for disclosing the schedule of analyst or investors meet if the same was already given in the code. SOP on materiality, if any, has to be aligned with this particular ISIN because there are several clarifications which have been introduced by this ISIN, and that will surely require changing or tweaking your current or existing SOP. Another very, very important actionable is on sensitizing your officers, your employees who are dealing with, the major functions in the entity, so that the event once occurred is escalated as soon as possible for the purposes of having prompt disclosure made by the listed entity. Now, as for event-based, at the time of WS ceasing to be so, of course, one has to assess if there was any indemnity or guarantee or surety. This listed holding entity was acting as a surety for the WS, and hence it has to be informed because once the WS ceases to be so, intimation will be required under Part A para B 11. At the time of invocation of a performance guarantee, that time also there will be an intimation requirement, and one has to assess the impact of such invocation by considering whether it is material or not. Receipt of communication from regulatory, statutory, enforcement, or judicial authority requiring disclosure under Regulation 30. And if an information is confidential or sensitive, that also has to be seen so as to accordingly submit the key elements of such disclosure. So that's it. Thank you very much for listening, and we'll love to have feedback on this video.